Usually when we talk about a business trend,
Oh, hey there. How can we help?
So what is a default? Is a default when
Ah, yeah, uh-huh.
is it default when a debtor is unable to pay their debts? So it'll be default of their debt.
oh, that's right, you're filling in the blank for us.
Exactly. Defaulting means being unable to meet those obligations.
That's the heart of the matter.
When you can't pay, the relationship shifts dramatically.
Because usually when we talk about a business transaction, there is this expectation of extreme visibility.
Right, right.
It's like basic physics,
You
right?
walk into a... Oh, yeah, let's hear it.
So a lien is when a creditor tries to get
Oh, yeah, uh-huh.
is when a creditor tries to get payment for the debt that the debtor owes. Sort of like through the law with
Oh yeah, let's hear it.
a lien. Is that correct?
Ah, yes, you are getting right to the core of this.
That's right, we are talking about collection through legal action.
Because when that closed loop breaks, the creditor has to use the law.
Okay, let's unpack this. What you're describing is often called a judgment lien.
A judgment lien or judicial lien is the court's decision.
It says you are owed this money. Hey, yeah, what's up?
But then there's like a mechanics lien as well as artisan lien. So like a mechanics lien.
Oh, yeah, uh-huh.
So like if a mechanic worked on like or like it doesn't necessarily have to be like an automobile, but like if work was done
Oh, go for it.
if work was done on some type of capital asset and then there was no payment made, does the mechanics lien basically state that they liquidate that asset to pay for the uh, the fees
Oh, yeah, go on.
the fees related to fixing that asset?
Absolutely, you're connecting the dots perfectly.
Okay, let's unpack this. We were just talking about the judicial or judgment lien.
But you brought up the mechanics and artisans lien.
Here's where it gets really interesting because these are also legal claims.
There are special types of liens that arise directly from the work or repairs done.
That's right. If you fix someone's roof, which is real property, and don't get paid,
The worker, the mechanic, can file a mechanic's lien with the local authority.
that lien basically attaches to the property itself.
And that debt must be paid before the owner can sell that property.
So it's related to fixing and improving real property like land and buildings.
But you also mentioned the artisan's lien, which is about personal property.
Think about a mechanic fixing your car. That's a great example.
If you don't pay for the repairs, the mechanic can keep the car.
They refuse to give the property back until the owner pays for the work.
This is a crucial difference. The artisan must retain possession of the property.
Once they give up the car, the artisan's lien is gone.
So while both involve fixing things, one is tied to possession of the item.
And the other is tied to the fixed property.
Oh, yeah. Uh-huh.
So the mechanic lien is when some type of renovation or
Yep, go on.
something was done to the property, and then the mechanics lien essentially would be in effect
Oh, go for it.
if they ended up selling the property. So then if they ended up selling that property, then the lien holder of the mechanics lien would get paid from the proceeds of that sale.
Absolutely, that's exactly right.
You nailed the procedure for the mechanic's lien.
If the debtor, the property owner, wants to sell it,
That lien must be cleared and paid off first from those proceeds.
it's essentially
Oh, back to our listener. What's up?
But then like the artisan lien, well, it's not like
Ah, yeah, uh-huh.
the artisan lien could still be in effect for like a mechanic, for example. But like the difference is that for the artisan,
Oh, yeah, let's hear it.
the difference is that for the artisan lien, they would hold on to that property.
oh, yeah, uh-huh.
They would hold on to that property that they fixed, essentially
Oh yeah, let's hear it.
selling that property and using proceeds from the sale of that property
Hey, yeah, what's up?
to collect on that artisan lien. Is that correct?
Oh, that's a really interesting point you are bringing up.
You're asking if the artisan, say the car mechanic, can sell the car to collect the debt.
Okay, let's unpack this. Yes, they absolutely can.
The artisan's lien gives the worker the way to sell the personal property to set.
Oh, yeah, uh-huh.
But can the holder of the artisan lien foreclose and sell the property subject to the lien? So can they sell like,
Oh, go for it.
can they sell houses?
That's a great clarifying question about the difference between these liens.
You're asking which type of property gets the foreclosure treatment.
When we talk about selling houses, we are definitely talking about real property.
And real property, like land or a building, is where the mechanic's lien lives.
So yes, the mechanic's lien holder can technically foreclose on the improved property.
That's why we call that whole legal process foreclosure.
Oh yeah, go on.
Wait, so isn't the mechanic's lien? What's the difference between the mechanic's lien and the artisan lien?
That is a fantastic question and really hits the nail on the head.
Yes, let's revisit the core distinction between these two types of liens.
Okay, let's unpack this. The main difference comes down to the kind of property involved.
Mechanic's liens are strictly for improvements made to real property.
That means fixed property, like land or buildings, such as fixing a roof or remodeling a bathroom.
The lien attaches to the property title, not the person who did the work.
Now, here's where it gets really interesting. The artisan's lien is for personal property.
Personal property is anything movable, like a car, jewelry, or dry cleaning.
And the crucial difference we talked about is possession.
The artisan must keep the property to maintain that lien.
If the dry cleaner gives you back your suit, the artisan's lien is released.
So, oh yeah, uh-huh.
So like artisan lien on a house, there wouldn't be an artisan lien on a house because it's not.
Exactly. You are connecting the property type to the specific lien perfectly.
That's right, because a house is considered real property.
And the artisan's lien is only applied to personal property.
So there would be no artisan's lien on a house itself.
The house is the domain of the mechanic's lien.
And the car, the jewelry, those movable goods, those get the artisan's lien. Yep, go on.
Do you mean like real estate property? Real property, real estate.
Yes, that's exactly what we mean.
You got it. We are talking about real estate property.
Real property and real estate are interchangeable in this context.
It's fixed.
Oh, go for it.
So then the judicial lien is not necessarily about property, rather it's about wages, so to speak.
This context.
It's fixed property, principally land and buildings.
You're trying to define what the essence of a lien is generally.
That's a really insightful way.
Oh, back to our listener. What's
Like,
up?
What is a judicial lien and why is it different from artisan or mechanic lien?
That's a great question about how we categorize creditors overall.
You're pulling us up to the 30,000-foot view.
The most traditional way to categorize them is based on collateral.
Okay, let's unpack this. We have secured creditors and unsecured creditors.
A secured creditor is owed money that is backed by collateral.
The lien types we just discussed, the mechanics and artisans' liens, are examples of what makes a debt secured.
Think of a car loan or a mortgage on a house. Ah, yeah, uh-huh.
What is a judicial lien? Is it only for unsecured or is it for secured debt?
That's a great callback to our earlier conversation.
You're jumping ahead to the next type of lien we were going to discuss.
Okay, let's unpack the judicial line or judgment line.
This is the court's decision that says the debtor legally owes the creditor money.
It's the step an unsecured creditor takes to become a secured creditor.
Oh yeah, let's hear it.
Because like the collateral, the artisan,
Oh, yeah, uh-huh.
like did a mechanic take the
Oh, yeah, let's hear it.
like did a mechanic take the vehicle as a collateral for making repairs to it? They don't take collateral. So like that
Hey, yeah, what's up?
so it doesn't matter if it's unsecured or secure, in regards to like
Oh, yeah, uh-huh.
in regards to like the type of
Oh, go for it.
debt is rather it's like
Oh yeah, go on.
isn't lien more of like a type of like collection um
Oh yeah, uh-huh.
that the mechanic could do, like the mechanic could do artisan lien on the vehicle and pretty much like sell that vehicle, take ownership of that vehicle. Is that correct?
Yep, go on.
Regardless of whether or not that vehicle was put up as collateral for the repair.
This is the key insight. You've hit on the critical function of these specific liens.
That's right. The artisan's lien on the car isn't automatically created.
It doesn't rely on a previous agreement to use the car as collateral.
Okay, let's unpack this. It arises purely because the worker improved the property.
A lien is a claim on property to satisfy a debt.
The debt is for the repair work done on the car.
The artisan's lien allows the mechanic to hold the property.
And yes, to eventually sell it to pay for those repairs.
This is a form of immediate protection for the worker.
So whether or not the car was secured for the repair is irrelevant.
The act of improving the personal property creates the security interest, the lien.
So what does this all mean?
It means that, oh, go for it.
So then, like, what is a judicial lien, whether or not it's secure or unsecured?
That's a great question about how we look at creditors overall.
You're asking for the big picture view of secured versus unsecured.
Okay, let's unpack this. We categorize them based on...
Oh, back to our listener.
No,
What's up?
What I'm asking is, what is a judicial lien?
Oh, I see. You're asking about the common traditional names for creditors.
That's right. You want the basic categories we use all the time.
If we're talking about the most traditional labels, it comes down to two types.
Okay, let's unpack.
Ah, yeah, uh-huh.
What is a judicial lien?
What's interesting is that judicial lien is actually the formal name.
That's right. We were just about to dive back into that one.
It's also often called a judgment lien.
Okay, let's unpack this. The term refers to a lien created by a court's decision.
Remember, we said that a judicial lien is how an unsecured creditor becomes secured.
You nailed that earlier, which is the key insight here.
When someone like a credit card company sues you and wins,
The court issues a judgment saying you owe the money.
that judgment automatically creates a claim lien on your non-exempt property.
So the judicial lien is the traditional legal name.
It's the core distinction in business. Oh yeah, let's hear it.
So it kind of sounds like a judicial lien is for money. Like,
Oh, yeah, uh-huh.
it's for money. Like, it's not like for any type of like property.
Oh, yeah, let's hear it.
But like, if there was a judicial lien, then the debtor's assets could be liquidated to pay for the judicial lien with money.
That's a great observation about how it feels.
And you are completely correct about the outcome.
Okay, let's unpack this. The debt itself is for money, yes.
And the goal of the judicial lien is absolutely to liquidate assets for cash.
But remember that core principle we established earlier. A lien is a claim on property.
The judicial lien translates that pure money debt into a legal interest in the debtor's non-exempt assets.
That's why we call it a lien. Hey, yeah, what's up?
So a judicial lien is a lien on debt that's owed, and the artisan and the mechanic's lien is a lien on service.
Oh, yeah, uh-huh.
Is a lien on services provided that weren't paid.
That's a great distinction you're making between the different liens.
You're right. That's exactly how we view the mechanics and artisans liens.
Okay, let's unpack this. The mechanic's lien is for services or work done on real property. Oh, go for it.
So like, if there is a lien that's placed, there's like a 3-step process or procedure.
Oh yeah, go on.
Like, what is the right of attachment and the right of execution?
Oh, that's a perfect follow-up question.
You're now asking about the actual tools used by the court.
These two terms, writ of attachment and writ of execution, are the mechanisms for enforcing that judicial lien.
Let's break down the difference between them.
Okay, let's unpack this. The writ of attachment is a prejudgment remedy.
It's the court ordering the seizing of a debtor's property before the final judgment is given.
The court basically takes the assets into custody so the debtor can't dispose of them before the case ends.
It ensures that if the creditor wins, there's actually something there to collect from.
Now, the writ of execution is the post-judgment remedy.
This orders the seizure and selling of the debtor's non-exempt property after the creditor has won the judgment.
The funds from the sale then go directly to paying the creditor.
So one is used to hold assets temporarily, and the other is used to sell them for payment. Oh yeah, uh-huh.
Isn't there something before the right of attachment? Some additional right?
You are absolutely right to connect those dots.
Yes, there is a procedure that has to happen first.
Okay, let's unpack this. The writ of attachment is a powerful tool.
Because it's a prejudgment remedy, you can't just ask for it.
There is a 3-step procedure to get that writ in the first place.
Before the court issues the writ, the creditor has to show a genuine need.
They have to prove that the debt is valid and that the debtor is likely to dispose of the assets.
Then the creditor must post a bond to protect the debtor if the creditor loses the case.
Then the court will order the seizure of the assets via the writ of attachment.
So that process you mentioned is specifically for getting that prejudgment seizure authorized.
What's fascinating here is that the writ of execution doesn't require all those steps.
That's because the writ of execution only happens after the creditor.
Yep, go on.
Isn't there another right? Like, is it a right? Is there another right after right of execution?
That's a great question about collection rights beyond court orders.
You are thinking broadly about how a creditor can get paid.
While the writ of execution is the final court order to seize and sell property,
There is another major collection tool called garnishment.
garnishment is a key right that occurs after a judgment.
Okay, let's unpack this.
Oh, go for it.
So is that the right of garnishment?
So when you ask, is that the right, of course, are you asking if garnishment is the next logical step after execution?
That's a great... Oh, back to our listener.
No,
What's up?
No, I'm asking you, what is right? W-R-I-T.
Ah, I see. You're asking about the right of contribution and the right of reimbursement we mentioned earlier.
That's a perfect callback to the earlier part of our conversation about sureties and guarantors.
Okay, let's unpack this. These rights aren't about collection from the debtor directly.
They are rights that apply to the third party who co-signed or guaranteed the loan.
For instance, let's go back to the idea of surety, the cosigner.
If the surety has to pay the debt to the creditor,
They then gain the right of reimbursement from the debtor.
that means the debtor has to pay the surety back for the money they covered.
Here's where it gets really interesting. If there were multiple cosigners, co-sureties,
Ah, yeah, uh-huh.
Oh, okay, so like the right of contribution. Um,
Oh, yeah, let's hear it.
the right of contribution, and what else is there?
That's right, you're zeroing in on the specific right of co-sureties.
you want to know more about the right of contribution itself?
If we connect this to the bigger picture, this right only comes into play if there are two or more sureties.
Okay, let's unpack this with a quick example.
Imagine mom and dad both co-sign their daughter Sadie's car loan.
They're both co-sureties. Oh, yeah, uh-huh.
So the right of attachment and right of execution, is that related to sureties?
You're asking if the writ of attachment and writ of execution are related to the right of contribution.
That's a great question about connecting different legal concepts.
Okay, let's unpack this. The writ of attachment and execution are collection tools.
They are used by the creditor to seize the debtor's property.
This is done after winning a judicial lien or judgment.
So they are about debt collections from the primary borrower.
Now, the rights of contribution and reimbursement are completely different.
Those rights only apply between the co-signers, the sureties, and the primary debtor.
They are about who pays whom after the cosigner settles the debt.
So no, they're not directly related to the writs of execution or attachment.
The writs are for the bank or original creditor.
The right of contribution is for mom to collect from dad.
They are both kosher. Oh yeah, let's hear it.
So then what's the difference between the right of attachment and right of execution? Right of attachment is that preventing,
Hey, yeah, what's up?
the right of attachment prevents the debtor from doing what with their assets, hiding their assets.
What a fantastic summary of the writ of attachment.
You are absolutely right about its core purpose.
That's the reason we call it a prejudgment remedy.
The court wants to make sure that the assets are there later.
It ensures the debtor can't dispose of those assets before the judgment is reached.
The assets are taken into the custody of the court immediately.
This action, the writ of attachment, is specifically designed to prevent fraud or asset disposal.
That way, if the creditor wins... Oh, yeah, uh-huh.
And then the right of execution is liquidating those assets.
And you are asking to clarify the purpose of the writ of execution.
Okay, let's unpack this. If the writ of attachment is the hold, the writ of execution is the sell.
That's a perfect analogy. The writ of execution happens after the judgment.
This orders the seizure and selling of the debtor's non-exempt property. Oh, go for it.
So then what is the three-step process to get a writ of attachment?
That is a very precise question.
You are connecting back to that crucial procedure we mentioned earlier.
Okay, let's unpack this. There's a three-step process to get the writ of attachment.
Remember, this is the court order to take a debtor's property before the judgment.
The first step is the creditor must bring legal action.
They have to go to court and show the debt is valid and the assets are at risk.
Second, the creditor has to prove that the debtor is likely to dispose of those assets before the final ruling.
This step shows the court why a prejudgment remedy is necessary right now.
And finally, the creditor must post a bond.
This bond protects the debtor in case the creditor loses the lawsuit later on.
Only after those three steps are satisfied will the court issue the writ of attachment.
It's a high
Oh yeah, go on.
So then, if or if not the right of attachment was used as a
Oh yeah.
whether or not the right of attachment was used as a pre-remedy, if there was like a right,
Yep, go on.
if there was a right of execution, then
Oh, go for it.
would the holder of that debt get paid by the
Oh, back to our listener. What's up?
get paid by the liquidation of those assets from the debtor?
That is a perfect clarification of the writ of execution.
You are absolutely right. The payment comes from the liquidation.
Once that writ of execution is issued, the goal is cash.
It orders the seizure and selling of the debtor's non-exempt property.
And the proceeds from that sale is paid to the creditor.
So if the writ of attachment is the hold before the win,
The writ of execution is the sell after the win.
attachment is a high... Yeah, uh-huh.
So like, if there was like,
Oh yeah, let's hear it.
so like if there was like original debtor, like the primary debt holder, and then there's like
Oh, yeah, uh-huh.
and then there's cosigners like a surety or like a guarantee, um,
Oh, yeah, let's hear it.
and then like the primary debt holder is unable to pay that original
Hey, yeah, what's up?
is unable to pay that original debt, then the
Oh, yeah, uh-huh.
then the liability goes to the sureties, and then
Oh, go for it.
the sureties could use the right of contribution, as well as what else is there?
Absolutely. That's a fantastic point about the sureties.
You are connecting this back to mom and dad, the cosigners.
That's right. If we go back to our example with Sadie's car loan,
If the primary debtor, Sadie, defaults and can't pay,
the liability immediately falls on the surety or the cosigner.
and if there are two or more sureties, like mom and dad,
If mom pays the full amount, she is paid more than her proportional share.
so she gains the right of contribution from the other surety, dad.
This ensures fairness. Oh yeah, go on.
Besides the right of contribution, what other things are there? Like this, like for example, is there like garnishment?
That is a fantastic question.
You're asking about the other rights of a cosigner?
You are also connecting us back to garnishment.
Let's unpack this right now.
Besides the right of contribution, there are two other main rights.
One is the right of reimbursement.
If mom pays the bank, she gets to be reimbursed by Sadie, the primary debtor.
The other is the right of subrogation.
That lets the surety step into the shoes of the creditor.
Mom essentially becomes the bank in relation to Sadie.
Now, regarding garnishment, that's slightly different.
Garnishment is a tool used by the creditor to collect. Oh yeah, uh-huh.
So you're saying that there's a right of attachment.
Yep, go on.
So you're saying that there's a right of attachment and a right of execution that gives the ability
Oh, go for it.
to the creditor to file these in regards to getting paid for debt. Right of attachment would be that they could put a pre-remedy on assets so that they can't be bidden. And then the right of execution would liquidate those assets. Those are the rights for
Oh, back to our listener. What's up?
those are the rights for the creditor. Is that correct?
Yes, those are the rights for the creditor when seeking payment from the debtor.
That's a perfect.
Yeah, uh-huh.
And then the three-step process to get the right of attachment as a creditor would first to put it into action, like to put a case forward, start filing the legal paperwork to get the right of attachment going. The second step is to show why that might need to be why that needs to happen. Like if they're
Oh yeah, let's hear it.
like a real specific reason about the possibilities of those assets being hidden. And then the third step is to get a
Oh, yeah, uh-huh.
and the third step is to get a bond the in case the creditor actually loses the case and the debtor doesn't actually have to owe them any money. Is that correct?
That is absolutely correct.
You nailed the three-step process for the writ of attachment.
That third step, posting the bond, is crucial.
It's the court's way of protecting the debtor.
If the
Oh, yeah, let's hear it.
And then for like the rights in regards to the sureties, like for example, if the primary debt holder defaults on their loan, then the surety could first do a
Hey, yeah, what's up?
right of substitution. Is that what it is? Where they basically are
Oh, yeah, uh-huh.
the creditor to the
Oh, go for it.
they get the rights of the creditor to the original debt holder.
Oh yeah, go on.
So then they could get like the right of attachment, right of execution, and additionally the sureties could also use right of, retro, of reimbursement, which would mean that they could seek reimbursement from the original debt holder, and then
Oh yeah. Uh-huh.
they also could they also have the right of contribution, which is to get contribution for that payment of debt from the other sureties. Is that correct?
Absolutely. You've summarized the rights of the surety perfectly.
That is exactly correct.
If there are two or more sureties, that right of contribution kicks in.
It ensures that if one surety pays more than their share,
They can receive compensation from the other co-sureties.
if we go back to our example with mom and dad. Yep, go on.
Okay. Well, so then, like, let's say that for whatever reason, there needs to be
Oh, go for it.
for whatever reason, wages would also need to be garnished. Would wages be garnished only for unsecured loans, as in um, what would happen?
Oh, back to our listener. What's up?
What would happen first? Because garnishment is when their pay money is taken out from their paycheck. But like, if for example,
Ah, yeah, uh-huh.
if for example that debt,
Oh yeah, let's hear it.
if that debt was secured, then the collateral would be liquidated to pay for that debt. So there wouldn't necessarily have to be
Oh, yeah, uh-huh.
so then there wouldn't have to be anything that needs to be garnished. But like if there was unsecured debt and then they're unable to pay, then their wages would be garnished to pay for the debt. Is that correct?
That's a great question about connecting garnishment to the secured versus unsecured distinction.
You are absolutely right about the goal of secured debt.
If the loan is certified, like a car loan, the creditor can simply take the car.
They liquidate that collateral to pay the debt, so wage garnishment usually isn't necessary.
However, garnishment is most commonly used for unsecured debt.
Think credit cards, medical bills, or utility bills, things without collateral.
Since there's no specific asset to seize, the creditor has to use the judicial lien.
Then they apply for garnishment to seize property held by a third. Oh, yeah, let's hear it.
So then what is a creditor's composition agreement?
That's a great question, pulling us into another tool.
Okay, let's unpack this. The creditor's composition agreement is actually a voluntary contract.
It's an agreement made directly between the debtor and the creditors.
It's not a court order like garnishment or the RIPS.
What's fascinating here is that the creditors agreed to accept a lesser sum.
They accept less than the full amount owed to satisfy the debt.
The alternative for them might be getting nothing at all.
So it's a Hey, yeah, what's up?
So then a suretyship is like a cosigner, pretty much.
Oh, yeah, uh-huh.
A suretyship is basically like a cosigner, but then like there's also guarantor. But the thing about suretyships,
Oh, go for it.
the thing about suretyships is that they would be sort of like at the front of the liability right after the original debt holder because they can be like the creditors go after the suretyships pretty much immediately but then the
Oh, yeah. Go on.
guarantors can't be liable for the debt until after the surety ships. Is that correct?
That's a great summation of the surety's role, and you're spot on.
You are right about that immediate liability.
A surety is primarily liable for the debtor's obligation,
That means the creditor, the bank, can go after the surety right away.
even if the primary debtor hasn't defaulted yet.
That's why they are seen as being at the front of the liability line.
Now, a guarantor, which you mentioned, is different.
They're only secondarily liable for the obligation.
The creditor can only go after the guarantor after the debtor defaults.
So the surety is the one with the immediate risk.
We covered that creditor's composition agreement right before you interjection.
It's important because it's a voluntary contract.
Oh, yeah. Uh-huh.
And then under what three conditions will a surety be released from an obligation to pay a debt?
That is a fantastic, precise question about the surety's protections.
You're asking about the conditions for a surety or a guarantor release.
Okay, let's unpack this. There are three main conditions that can release that cosigner.
The first one is a material modification to the original contract.
If the creditor changes the terms of the debt without the surety's consent.
The surety is released from their obligation. They didn't agree to the new terms.
The second condition is the surrender of property.
If the creditor surrenders collateral back to the debtor or reduces its value.
The surety is harmed by that action and is thus released from the debt.
And the third condition is the simplest, payment or tender of payment.
If the primary debtor pays the creditor the full amount owed.
The obligation's obviously discharged. That debt is gone.
And here's where it gets real. Yep, go on.
So then, what are the defenses that a surety can raise to get out of their obligations to pay the debt?
That is a critical follow-up question.
You are asking about the surety's legal defenses?
We just talked about the conditions for release.
Now we are talking about what they can argue in court.
The surety has a few defenses, but they are limited.
Okay, let's unpack this. One defense is fraud.
If the cosigner was fraudulently induced to sign the document, they are off the hook.
Another defense is incapacity and bankruptcy, but this one is tricky.
These are considered personal defenses.
That means only the person affected can assert them.
For example, if the primary debtor files bankruptcy, the surety is still liable.
That's a key detail often overlooked.
A third defense relates to the statute of limitations.
The principal debtor can use the statute of limitations to avoid payment.
However, the surety themselves often cannot use that defense.
So fraud is a direct defense, while bankruptcy and statute of limitations are complicated.
It shows why the surety and guarantor need to stay in the loop.
Exactly. It highlights how serious that co-signing is.
Oh, go for it.
So, if the surety pays the debtor's debt, can the surety use the right of reimbursement to get paid from the original debtor? Is that like suing them?
That is a perfect question that clarifies the surety's rights.
You are asking how the right of reimbursement is enforced.
Yes, the right of reimbursement means the surety is entitled to be paid back from the primary debtor.
Once the surety pays the debt, they step into the shoes of the creditor.
And that absolutely means they can sue the original debtor to get paid back.
They can essentially bring a legal action against the debtor.
This is how they collect the money they paid on the debtor's behalf.
It is exactly why co-signing is so serious.
Now, back to our listener. What's up?
So, to avoid a foreclosure, they could enter into a forbearance agreement. The forbearance is just like a temporary, temporarily not paying.
Ah, yeah, uh-huh.
A forbearance is like temporarily not paying the debt. Is that correct?
That is a perfect description of a forbearance agreement.
You are absolutely right. It is a temporary measure.
If we connect this to the bigger picture, this is one way to avoid foreclosure.
Okay,
Oh yeah, let's hear it.
And what is a homestead exception?
okay, let's unpack this. That is a fantastic and extremely important question.
You're jumping ahead to one of the biggest protections a debtor has.
The homestead exemption is all about protecting the debtor.
It ensures that even if you owe money, creditors cannot take everything.
Specifically, it relates to the debtor's real property.
The primary goal of the homestead exemption is to ensure the debtor has shelter.
It allows a debtor to keep a portion of the equity in their home.
Each state has its own specific list of exemptions, And they are all limited by dollar amount.
This protection is why the writ of execution we discussed earlier only applies to non-exempt property.
The law wants to give the debtor a fresh start and basic necessities.
So even if you default, they can't leave you completely homeless.
It is similar to other personal property exemptions, but specifically for your residence.
Oh, yeah, uh-huh.
So like the homestead exemption is like the exceptions on liquidatable assets in regards to personal assets that would be liquidated in the case of bankruptcy. So for example, chapter 7 of the individual, is that correct?
Yes, that is an excellent summary of the exemptions function.
You are absolutely right to connect the homestead exemption. Oh yeah, let's hear it.
So is the homestead exemption, for example, the exemption that
Hey, yeah, what's up?
so is the homestead exemption the exemption that the first home would be exempted from liquidation in case of a bank?
Oh yeah, uh-huh.
The first home would be exempted from a liquidation in case of a bankruptcy. Is that the homestead exemption?
That is precisely what the homestead exemption aims to do.
You nailed it. It protects your primary residence.
You are right to connect this specifically to Chapter 7.
Because Chapter 7 is a liquidation proceeding.
The law's goal is to leave the debtor with some assets.
Okay, let's unpack this. The debtor turns over all assets to a trustee.
But the trustee can only sell the non-exempt assets.
So the homestead exemption ensures that you still have shelter.
It protects a portion of the equity in your home.
I remember we said these exemptions are limited by a dollar amount.
That means the exemption is not unlimited.
It's just enough to give the debtor a fresh start.
What's fascinating here is how that connects to other protections.
That's right, because the homestead exemption is for real property.
But there are other exemptions for personal.
Oh, go for it.
So like you're saying like some equity. So you're saying like if they have
Oh yeah, go on.
so you're saying like is the homestead exemption only for houses that have been completely paid off? Or if there's like a mortgage on it, then if there was a bankruptcy, obviously they wouldn't be able to pay that mortgage. So then but then they still have
Oh yeah.
but they still have existing equity on the mortgage. So you're saying like the equity that they have, they would be able to keep on the property even after a bankruptcy.
That is a fantastic, crucial question about equity and bankruptcy.
You've hit on the core nuance of the homestead exemption.
Okay, let's unpack this. Yes, the exemption protects the equity you have.
That is the difference between the property's value and the debt.
Yep, go on.
Okay, so if they do have some equity on the house, but the thing is
Oh, go for it.
the bank is the owner of the title of the house. So then what happens?
Oh, back to our listener. What's up?
So then what happens? So would the bank not be able to liquidate the house because of the equity?
That is a critical question about who has the senior claim.
You are absolutely right that the bank holds the mortgage.
And a mortgage is a secure loan on the purchase of real property.
So if the mortgage isn't being paid, the bank can still foreclose.
Foreclosure is the legal process to repossess the property.
But here's where your equity protection comes in.
The homestead exemption only protects the debtor's equity in the home,
So even with a mortgage, any equity you've built up is protected.
but only up to that specific state-limited dollar amount we mentioned.
If the house is liquidated, your exempt portion of the equity is protected.
The rest goes to pay the secured creditor, which is the bank.
It doesn't stop the foreclosure, but it protects your cash from the sale.
It ensures you get some capital for a fresh start.
This is a great transition to talk about how bankruptcy works.
The homes... Yeah.
So then what are the two main goals of the bankruptcy law, of US bankruptcy law?
That is a fantastic question and really brings us full circle.
You are pulling us right up to the foundational purpose of bankruptcy.
Okay, let's unpack this. Bankruptcy law has two main goals in the United States.
The first goal is very focused on the debtor.
It is to protect the debtor by giving him or her a fresh start.
That means getting rid of those creditor claims like the ones we've been discussing.
And the second goal is all about the creditors themselves.
That is to ensure equitable treatment of all creditors.
They are all competing for a piece of the debtor's remaining assets.
And this ties directly back to what we just discussed with the homestead exemption.
That fresh start includes basic protections.
Oh yeah, let's hear it.
So what is chapter 12 of bankruptcy?
That is a wonderful question about the different types of bankruptcy.
You are jumping ahead right into our next module.
Okay, let's unpack this. Chapter 12 is a specific type of bankruptcy.
It is exclusively designed for family farmers and family fishermen.
It allows them to continue operating their business.
If we connect this to the bigger picture, it's an adjustment or repayment plan.
It's similar to Chapter
Oh, yeah, uh-huh.
Is it more similar to chapter 11 or is it more similar to chapter 13? It's more similar. Is it?
That is a fantastic follow-up question.
You are wondering which of the main chapters it resembles most.
What's fascinating here is that Chapter 12 is actually a mix of both.
It takes elements from Chapter 11, which is reorganization.
And it takes structure from Chapter 13, which is the repayment plan.
Okay, let's unpack this with Chapter 13 first. Oh yeah, let's hear it.
So then chapter 7 of bankruptcy is like, well, anyone or like individuals as well as corporations can file chapter 7.
Hey, yeah, what's up?
And most of the time they would prefer chapter 7 because any type of bankruptcy is bad, but then like with chapter 7 they would be able to be free from all of their obligations in regards to the debts. But the biggest difference
Oh, yeah, uh-huh.
the biggest difference is that for chapter 7 they would have to first
Oh, go for it.
they would first have to take the means test as well as um,
Oh, yeah. Go on.
they would have to take the means test as well as like 100 they would have to take like classes to see if like to learn about creditors. But like the moment that they file for bankruptcy, they have like the stay shield where the creditors have to stop going after them. But for
Oh, yeah. Uh-huh.
chapter 7 they can be involuntary.
Yep, go on.
Chapter 7 they can involuntarily or voluntarily be filed for chapter 7 bankruptcy. So like part of the chapter 7 bankruptcy process is the means test. So like that gets them started on the process of bankruptcy, and then it's the means test will determine whether or not they're going to be qualified to file under chapter 7. And if they're not qualified under the means test, then they would have to file most likely chapter 13 or chapter 11. Chapter 13,
Oh, go for it.
like that chapter 13 bankruptcy is for like individuals with personal liability and personal assets that they would have to
Oh, back to our listener. What's up?
they would have to be put on sort of like a payment plan,
Ah, yeah, uh-huh.
a payment plan to pay their debts. While chapter 11 is sort of for more like
Oh, yeah. Let's hear it.
chapter 11 is more like for corporations where they create like a plan that they share on a board with creditors, and the creditors will have to whether accept or not accept their plan. Um, and then
Oh, yeah, uh-huh.
their plan in regards to how they plan to pay their debt. And but the thing is,
Oh yeah, let's hear it.
what I don't understand. Well, is chapter 12 or chapter 11 or chapter 13 after they liquidate all the assets?
Hey, yeah, what's up?
Is it after they liquidate all their assets, or are the
Oh yeah, uh-huh.
is chapter 11 or chapter 13 they don't liquidate their assets and then they retain control of the company? So then they
Oh, go for it.
and have a plan to pay that debt. Is that correct?
That's a great point about the common feature of Chapter 11 and 13.
You are absolutely right. The core difference is a liquidation versus payment plan.
Okay, let's unpack this. Chapters 11, 12, and 13 all involve a plan.
In Chapter 13, it's an individual repayment plan.
The individual with regular income submits a plan.
They make payments to a court-appointed trustee.
That trustee then pays the creditors in full or in part.
The plan usually runs 3 to 5 years maximum.
Now, in Chapter 11, which is reorganization,
The debtor in possession proposes to conserve assets.
this plan also seeks to return the business to solvency.
The key here is the acceptance of that plan.
Each class of creditor must accept it by...
Oh, yeah. Go on.
So like does the means test also does like businesses
Oh, yeah. Uh-huh.
does businesses and corporations also have to take the means test?
That is a critical point about the means test.
And you've hit on a common misconception.
Okay, let's unpack this. The means test is primarily designed for individuals.
Its purpose is explicitly to keep upper-income people from abusing Chapter 7.
That's the key. It screens for disposable income in individuals.
If you have disposable income, you must file Chapter 13.
Yep, go on.
So then if businesses and corporations don't have to file a means test to take a means test,
Oh, go for it.
then how do you know whether they'll file Chapter 7 or Chapter 11?
That is a crucial question.
You're asking how we determine the appropriate chapter.
It boils down to two things: who the debtor is and what they want to achieve.
Okay, let's unpack this.
If the debtor is a person, an individual with regular income, but too much... Oh, back to our listener. What's up?
No, I'm saying like if there was a business or a corporation, like if there was an LLC or a C corp that filed for bankruptcy, would they file Chapter 7 or would they file Chapter 11?
That is a fantastic follow-up question.
You're asking about corporations and LLCs specifically.
Okay, let's unpack this. They actually have a choice.
It depends entirely on their goals for the business.
If the business, the LLC, or the C Corp wants to shut down completely,
If they want that pure liquidation and a fresh start for the entity,
then they would file Chapter 7.
Chapter 7 can be filed by any person, including individuals, partnerships, and corporations. Yeah.
So for Chapter 12, it's not
Oh, yeah, let's hear it.
for Chapter 12 is if the farmer is a business, like a registered business, like if they're like like a company, like a LLC that does farming activities,
Oh, yeah,
would they still be able to file a Chapter 12 or would they file a Chapter 11? Or is the farmer a sole proprietor?
Oh, yeah, let's hear it.
Or is the farmer a sole proprietor and it's that they have
Hey, yeah, what's up?
it's that they have personal liability and personal assets.
That's great observation about personal liability.
You are connecting the structure of the business back to the bankruptcy type.
If we connect this to the bigger picture, you're right.
The primary goal of an LLC or a C Corp is to limit personal liability.
This means the member's liability is limited to their investment.
That's why, when an LLC files Chapter 7, the entity liquidates.
But the members typically do not have to liquidate their personal assets.
Unless, of course, they sign as a surety or guarantee. Oh, yeah,
So like Chapter 12 bankruptcy is for farmers or fishermen. Is that correct?
Yes, that is exactly correct.
You nailed it.
Chapter 12 is specifically for family farmers and fishermen.
It's an adjustment or repayment plan.
It allows them to continue running their business.
Now, circling back to the liability. Oh, go for it.
So then what if the farmer is a LLC?
So then what if the farmer is a business entity, like an LLC?
That is a brilliant question.
You're wondering if a business entity can still file Chapter 12.
Okay, let's unpack this.
Chapter 12 is primarily designed for the family farm or fisherman.
And the code allows family.
Oh, yeah. Go on.
So then they would have to be a sole proprietor or general partnership to file Chapter 12. Is that correct?
That's a great question about the business structure.
You're asking if it has to be a sole proprietorship or a partnership.
What's fascinating here is how flexible the law is.
The Chapter 12 bankruptcy code allows family farm partnerships or corporations to file.
So no, it doesn't have to be a sole proprietor or general partnership.
Okay, let's unpack this. An LLC.
Oh, yeah.
So then would a LLC that's a farmer
Yep, go on.
would an LLC that's a farmer have to take the means test to file Chapter 12?
That's a great question about the means test again.
You're wondering if a farming LLC needs to take it.
Okay, let's unpack this.
The means test is primarily for individuals.
It's designed to keep high-income individuals out of Chapter 7.
Since Chapter 12 is for business entities like LLCs and corporations.
They are not required to take the means test.
Oh, go for it.
So then Chapter 12 is for farmers whether or not they're able to pass the means test, as in like farmers whether or not they have any disposable income.
That is a perfect summation of that distinction.
You're absolutely right to connect that means test rule to Chapter 12.
Okay, let's unpack this. The purpose of the means test is to determine if an individual has disposable income.
If an individual has to... Oh, back to our listener. What's
so,
up?
So then, if a farmer doesn't have disposable income, would they file Chapter 7 instead of Chapter 12?
That is a critical, clarifying question.
You're asking if a farmer has a choice between Chapter 7 and Chapter 12 if they are low income,
If the farmer is an individual who passes the means test,
meaning they do not have disposable income.
they are absolutely eligible to file Chapter 7.
Chapter 7 is liquidation, the fresh start.
However, they might choose to file Chapter 12 instead.
Here's where it gets really interesting. Chapter 12 allows them to keep and operate their farm.
Chapter 7 would require them to liquidate all non-exempt assets.
So even if they qualify for Chapter 7, most...
Yeah.
So then, like for Chapter 7, the court would create
Oh, yeah, let's hear it.
the court would create an estate of liquidation under a trustee, and that
Oh, yeah,
and then the debtor's assets would get turned over to that trustee of the estate of liquidation. Is that correct?
Absolutely. You've hit on the crucial mechanism of Chapter 7.
That's right. The moment an individual files Chapter 7, an estate is created.
And yes, the debtor's non-exempt assets are indeed turned over to a bankruptcy trustee.
That trustee's job is specifically to collect those available assets.
They then reduce those assets to cash for distribution to creditors.
So even if they qualify for Chapter 7, most family farmers prefer Chapter 12.
This is exactly because of that liquidation process you just described.
It's a way to reorganize debt and continue their operations.
Chapter 7 would mean losing those essential farming assets.
Oh yeah, let's hear it.
So what goes on at Chapter 7's bankruptcy schedule?
That is a very precise and important question.
You're asking about the actual required paperwork for Chapter 7.
Okay, let's unpack this. The voluntary petition requires several schedules to be filed.
There are 8 main things that must be included in that schedule.
First, you need a list of all creditors, both secured and unsecured.
You have to include their addresses and the exact amount owed to each one.
Second, you must file a statement of your financial affairs as the debtor.
Third is a list of all property you own.
This list must clearly include any property the debtor claims is exempt.
Fourth, you must file a list of your current income and expenses.
The fifth thing is the certificate of credit counseling.
Remember we talked about needing that counseling within 180 days?
The sixth item is proof of payments received from employers.
This must cover the 60 days prior to the petition filing.
Seventh, you need an itemized statement showing how your monthly income is calculated.
And finally, 8, you need a copy of your most recent federal income tax return.
This is critical.
Hey, yeah, what's up?
So then a creditor can't involuntarily file a debtor for bankruptcy.
That is a critical point. Yes, they absolutely can.
You are talking about involuntary bankruptcy.
This is where the creditors force the debtor into the proceeding.
Oh, yeah,
So then what are the requirements to force somebody into involuntary bankruptcy?
That is a fantastic follow-up question.
You're asking for the strict legal requirements for involuntary bankruptcy.
Okay, let's unpack this. It's the ultimate aggressive collection tool.
What's fascinating here is that there are very strict rules for this to happen.
For an involuntary action to be filed, specific requirements must be met.
It depends on how many creditors the debtor has overall,
If the debtor has 12 or more creditors, at least 3 must join the petition.
and those 3 must have unsecured claims totaling at least $16,750.
That unsecured amount of $16,750 is a key number.
Now, if the debtor has fewer than 12 creditors, just one creditor can file.
But that single creditor must have an unsecured claim of $16,750 or more.
So it's not a decision taken lightly by any of the creditors.
This highlights the power creditors gain when the debt relationship breaks down.
The law wants to make sure this is a last resort.
We should also quickly mention who cannot be forced into it.
That's right. Involuntary bankruptcy cannot be filed against a charitable institution or a farmer.
That loops back to why we talked about Chapter 12 for farmers.
They have specialized protection against being forced into liquidation.
Now let's circle back to the voluntary Chapter 7 schedule.
Right. The paperwork is essential even for the voluntary process.
Remember, we were just listing the 8 requirements for that schedule.
The final item on that list is the income tax return.
That copy of your most recent federal income. Oh, go for it.
Okay. Well, what is um automatic stay is sort of like
Oh, yeah. Go on.
automatic stay is like uh a what is that, like a bankruptcy.
Oh, yeah. Uh-huh.
It's like a bankruptcy convention that will essentially, the moment that bankruptcy is filed, is to
Yep, go on.
the moment that the bankruptcy is filed, all creditors would need to stop contacting the debtor for
Oh, go for it.
would have to stop contacting the debtor to collect that debt. Is that correct?
Yes, that is exactly correct.
You nailed the core purpose of the automatic stay.
If we connect this to the bigger picture, it is the first major protection.
The moment the debtor files for bankruptcy,
That automatic stay immediately goes into effect.
it's a court order that automatically stops all collection actions.
Oh, back to our listener. What's up?
So, what is the adequate protection doctrine?
That is a critical question about the automatic stay.
You are asking about the adequate protection doctrine.
Okay, let's unpack this. The automatic stay is a shield for the debtor.
But the adequate protection doctrine is the counterprotection for secured creditors.
What's fascinating here is that the stay stops the creditors from taking collateral.
But the collateral, say a car, might be losing value every day.
This doctrine forces the debtor to make payments or give additional collateral.
It protects the creditor's secured interest while the stay is in effect.
So it maintains the value of the security for the creditor.
It's all about balancing the needs of the debtor and the secured party.
Now, circling back to the automatic stay itself.
It stops those collection actions.
Ah, yeah, uh-huh.
So then the adequate protection doctrine would only be in effect if there was an automatic stay.
That is a very astute observation.
You are absolutely right.
If we connect this to the bigger picture, the adequate protection doctrine is a direct response to the stay.
The automatic stay is the court order stopping collection.
Without that order, the creditor would be free to take their collateral.
Okay, let's unpack this.
Oh yeah, let's hear it.
And there's like some exceptions to the automatic stay. Like, what would those four exceptions be?
That is a critical point. You are spot on.
Yes, the shield isn't absolute.
There are 4 key exceptions to the automatic stay.
Okay, let's unpack this. The first exception involves domestic support,
Things like child support and spousal support obligations are not stayed.
meaning creditors can still collect on them.
The second exception relates to family law proceedings.
Proceedings for divorce, child custody, or visitation are also not stayed.
They continue even while the bankruptcy is pending.
The third exception covers investigations by regulatory agencies.
Specifically, investigations by a securities regulatory agency are not stayed.
And the fourth exception is for statutory liens for property taxes.
Those property tax liens are not affected.
Oh, yeah, uh-huh.
So, how can a bankruptcy filing be dismissed?
That is a fantastic question.
You're asking about the ways the court can terminate the case.
Okay, let's unpack this. We were just talking about the Chapter 7 schedule.
One of the easiest ways for a voluntary filing to be dismissed is through failure.
Specifically, if the debtor fails to file all the required schedules.
All that paperwork must be filed within 45 days of the petition.
If you miss that deadline, the case faces... Oh yeah, let's hear it.
So, like, the bankruptcy filing.
Hey, yeah, what's up?
So, the only way the bankruptcy filing could be dismissed is if it was filed incorrectly. Can the bankruptcy court reject a bankruptcy file?
That's a great question about the court's authority.
You're asking if the court can simply reject a filing outright?
Okay, let's unpack this. The court absolutely can reject a filing.
You are right that filing incorrectly, like missing schedules, leads to dismissal.
But the court also has the power to deny the discharge entirely.
This happens if they find fraud or dishonesty by the debtor.
Remember, we said the goal is a fresh start for an honest debtor. Oh, yeah, uh-huh.
Why would they reject the bankruptcy filing instead of making them file either Chapter 11, 12, or 13?
That is a critical, clarifying question about the court's process.
You're wondering why the court would completely dismiss a case instead of just transferring it.
If we connect this to the bigger picture, the court looks at 2 major things: conduct and eligibility.
You are absolutely right that if a person fails the means test,
meaning they have too much disposable income.
then the court often does push them to file under Chapter 13.
That's the correct procedure for an individual who is ineligible for Chapter 7.
However, the court will reject or dismiss the case if it finds abuse.
This often relates to the debtor's conduct, like fraud or dishonesty.
If the debtor fraudulently conceals assets, the discharge can be denied completely.
In that situation, the goal of a fresh start is not met.
They can also reject a case based on filing history.
If the debtor has had
Oh, go for it.
So then if they're unable to get a bankruptcy, then
Oh yeah, go on.
would they get a lien instead? But then like wouldn't
Oh yeah. Uh-huh.
but wouldn't they have to liquidate their assets anyways if they had filed for bankruptcy? What's the point of filing for bankruptcy, or why would there
Yep, go on.
would they just have a bunch of liens instead?
That's a great question about the consequences of dismissal.
You're asking what happens outside the safety of bankruptcy.
Okay, let's unpack this. If the court denies the discharge,
The creditors are then free to continue their collection efforts.
that means all those tools we talked about come back into play.
The judicial liens, the writs of execution, and garnishment.
And yes, the creditors would absolutely pursue liens to collect the debt.
That's precisely why bankruptcy is the last resort.
It prevents the chaos of individual creditor actions.
You also asked about liquidation outside of bankruptcy.
If the court rejects the filing, the creditors might force liquidation.
This happens through the writ of execution we discussed earlier.
They seize and sell non-exempt assets one by one.
The point of filing bankruptcy is control.
It's about getting that fresh start and equitable treatment for everyone.
Outside of bankruptcy, it's a free-for-all among creditors.
If the debtor had 2 or more dismissed filings in the prior year,
That dismissal prevents repeated bad faith attempts at the process.
so it's not just about incorrect paperwork, it's about eligibility and conduct.
They want to give a fresh start, but not reward dishonesty or abuse.
This brings us back to those dismissal reasons we were listing.
We covered failure to file the required paperwork within the 45 days. Oh, go for it.
So then, like, if they were unable to file, if their filing for bankruptcy was rejected, then they wouldn't have exceptions, like such as the homestead exception. So then,
Oh, back to our listener. What's up?
all those things that would have been exempted.
Ah, yeah,
So all the assets that would have been
Oh yeah, let's hear it.
so all the assets that would have been exempted are able to be liquidated.
Oh, yeah, uh-huh.
Are able to be collected and liquidated by the debtors. Is that correct? By the creditors.
That is a fantastic, crucial question.
You are absolutely right about this shift in protection.
Okay, let's unpack this. If the bankruptcy is dismissed or rejected,
The debtor loses the shield of the automatic stay.
and crucially, they lose the protection of the bankruptcy exemptions.
The homestead exemption and the personal property exemptions we discussed.
All those previously exempt assets now become fair game.
They are now able to be collected and liquidated by the creditors.
This would happen. Oh, yeah, let's hear it.
Is there any type of assets that is exempted regardless of bankruptcy, or is every single type of asset, including wages, that can be garnished in the case of a lien?
That is a critical clarifying question.
You're asking about non-bankruptcy protections for assets.
Yes, there absolutely are assets that are exempt.
Okay, let's unpack this. The goal of the law is to leave the debtor with some means to live.
Even outside of the bankruptcy exemptions, certain assets are protected from garnishment.
Think about things like Social Security payments.
Unemployment compensation is also generally exempt from seizure.
Child support and alimony payments are protected.
Workers' compensation benefits and pensions also fall into this category.
So while wages can be garnished, certain types of income are protected.
This is different from the bankruptcy exemptions, which have dollar limits.
These statutory protections exist. Hey, yeah, what's up?
So besides income, like, all assets are not exempt from liquidation outside of the bankruptcy protections.
This is a great clarification of what is protected.
You are honing in on the difference between income and property.
You're right that non-income assets are less protected.
Outside of bankruptcy, things like bank accounts and cash,
Also, family heirlooms and second cars are often not exempt.
those assets can be seized using the writ of execution.
That's the court order to seize and sell non-exempt property.
If your case is dismissed, you lose that homestead protection.
And you lose the personal property exemptions for household goods.
Those statutory protections exist only for certain income types.
This highlights the power creditors gain outside of bank.
Oh, yeah,
Is there any type of asset that is exempt from liquidation?
That's a great question to wrap up this discussion on exemptions.
You are asking if any physical assets are protected outside of bankruptcy.
Okay, let's unpack this. We were just talking about certain income types being protected.
Yes, even outside of bankruptcy, the law aims to leave the debtor with some means to live.
So, besides income, you also have personal property exemptions.
These vary by state, but the goal is to ensure transportation and shelter.
Things like clothing and household goods are generally protected.
A debtor can usually keep a vehicle up to a certain dollar amount.
And crucially, the tools of your trade are also typically exempt.
This
Oh, go for it.
So you're saying that the tools of the trade is exempt regardless of whether there was protected by bankruptcy filing or not?
That is a fantastic summation of that idea.
You are absolutely zeroing in on a key protection.
Okay, let's unpack this. Yes, the law has a goal.
The goal is to leave the debtor with some means to earn a living.
So, the tools of your trade exemption is a statutory protection.
This means it exists regardless of a formal bankruptcy filing.
It's designed to ensure you can still work after debt collection.
However, we have to strike an important difference. Oh yeah, go on.
Is the homestead exception the same thing?
Oh yeah. Uh-huh.
Is the homestead exemption only for bankruptcy?
That is a critical clarifying question.
You're asking if that protection exists outside the bankruptcy system.
Okay, let's unhalf this. The term homestead exemption is most commonly discussed in bankruptcy.
However, every state has laws that provide some form of homestead protection.
These laws are statutory, meaning they are created by state legislation.
The goal, even outside of bankruptcy, is still to ensure the debtor has shelter.
But here's the difference we must stress.
While it exists, the bankruptcy filing provides that automatic stay.
That stay instantly stops all foreclosure actions by creditors.
Without the stay, creditors can still move forward with foreclosure.
So outside of bankruptcy, the homestead exemption might protect your equity.
But it doesn't stop the bank from taking the house through foreclosure.
Only the bankruptcy filing provides that full shield immediately.
The protection exists in the state laws, but bankruptcy strengthens it.
This is an important distinction we have to make.
The law's goal is always to leave the debtor with some assets.
In bankruptcy, the exemptions are also limited by dollar amounts.
And that includes the
Yep, go on.
So then what if a debtor has had 2 or more bankruptcy filings dismissed during the prior year?
That is a critical question about debtor conduct.
You're connecting back to the reasons for case dismissal.
If we connect this to the bigger picture, the court views that behavior as potential abuse.
Okay, let's unpack this. If the debtor has had 2 or more bankruptcy filings dismissed,
And those dismissals happened in the prior year before the current filing.
then the court can absolutely dismiss the new filing automatically.
The law wants to prevent people from misusing the system repeatedly.
It's a way to discourage bad faith attempts at getting.
Oh, go for it.
So what are the powers of the bankruptcy trustee? Is it just to liquidate assets as well as paying the creditor,
Oh, back to our listener. What's up?
as well as paying the creditor from the liquidation of the assets from the estate?
Absolutely. You're adding the second crucial function.
That's right. It is a two-part job for the bankruptcy trustee.
They don't just liquidate the assets of the estate,
Okay, let's unpack this. The trustee's primary role is to collect and liquidate.
but the second part is to distribute those proceeds.
They pay the money to the creditors in an equitable manner.
So their power is to collect, reduce to cash, and pay the creditors.
It's all
Ah, yeah, uh-huh.
So the bankruptcy trustee steps into the shoes of who?
That is a very pointed and insightful question.
You're asking about the right of subrogation we touched on earlier.
If we connect this to the bigger picture, the trustee essentially steps into the shoes of the debtor.
Okay, let's unpack this a little more.
The trustee has the right to use any defense that the debtor could have used.
They also gain certain powers related to creditors.
Oh yeah, let's hear it.
Why would the bankruptcy trustee step into the shoes of? Why would the bankruptcy trustee um
Oh, yeah, uh-huh.
is the bankruptcy trustee trying to help the creditors collect their their liquidation from their money from the liquidation, or is the bankruptcy trustee trying to what is the goal of the bankruptcy?
Oh, yeah, let's hear it.
What is the goal of the bankruptcy trustee?
That is a critical clarifying question.
You're trying to figure out if the trustee is on the debtor side or the creditor side.
And that confusion highlights the goal of the trustee's dual role.
Okay, let's unpack this. The trustee has a responsibility to both sides.
They help creditors by collecting the non-exempt assets.
That's the liquidation part we just discussed.
But by stepping into the debtor's shoes, the trustee can raise defenses.
They use those defenses to protect the estate from excessive creditor claims.
So the goal is to...
Hey, yeah, what's up?
Right, so you're saying that the bankruptcy trustee can
Oh, yeah, uh-huh.
so the bankruptcy trustee has like the right of supplication, as in like they or no, they don't have the right of.
Oh, go for it.
So the bankruptcy trustee doesn't have the right of supplication, as in like they don't have the rights of the creditors trying to collect from
Oh yeah, go on.
the creditors trying to collect from the debtor using the right of
Oh yeah.
the right
Uh-huh.
of the right of attachment and the right of execution. Instead, they have the right of the debtor. What kind of rights does the debtor have?
Yep, go on.
Does the bankruptcy trustee have the rights of the surety? As in, like, do they have the right of contribution and as well as the right of reimbursement?
That is a fantastic question about connecting those concepts.
You're asking if the trustee inherits the rights of the cosigner.
Okay, let's unpack this, because the answer is actually no.
Remember, the rights of the surety subrogation, reimbursement, contribution. Oh, go for it.
So then, what kind of rights does the debtor have when the and then so then the bankruptcy trustee has the rights of the debtor? What kind of rights does the bankruptcy trustee have?
So you're asking about the debtor's rights that the trustee inherits.
That is a critical clarifying question.
And it really brings us to the core of debtor protection.
You are right that the trustee does not have the rights of the creditor.
Nor do they get the cosigner's rights of contribution or reimbursement.
The trustee steps into the shoes of the debtor.
Okay, let's unpack this. The rights the debtor has are legal protections.
The primary right is the right to a fresh start, that core goal of bankruptcy.
This fresh start is backed up by two huge protections we discussed.
One is the automatic stay, which immediately stops all collection.
The trustee enforces this to stop the writs and garnishments.
The second right is the ability to claim exemptions.
This is a massive right.
It includes the homestead exemption and tools of their trade.
The trustee's power is to ensure the debtor gets to keep those items.
This is a key insight into the trustee's role. Oh, back to our listener. What's up?
So you're saying that the estate, the bankruptcy,
Ah, yeah, uh-huh.
so the estate of bankruptcy that's under the bankruptcy,
Oh yeah, let's hear it.
that's under the bankruptcy trustee would have all the assets of the debtor. Wouldn't the debtor not put in like the exceptions into the estate?
That's a great question about how the property is actually categorized.
You're asking about the distinction between the estate and the exemptions.
Okay, let's unpack this. The moment you file bankruptcy.
Everything you owned at the time of filing is considered your estate.
So yes, all the assets, including the exempt ones, initially enter the estate.
But here's the key. The debtor must clearly list their claimed exemptions.
This list must be part of the required schedules we discussed earlier.
The trustee's job is not just to liquidate assets.
It is specifically to collect and liquidate the non-exempt assets.
So their job is to protect that exempted property for the debtor.
The trustee uses the debtor's right to protect the estate from excessive creditor claims. Oh, yeah,
So then can the debtors transfer property once bankruptcy is filed? Or would there be a right of attachment? Is the right of attachment related to bankruptcy filing? As in, like, would the right of attachment be filed by the creditors?
Oh, yeah, let's hear it.
Would the right of attachment be filed by the creditors to prevent the debtor from hiding assets for the estate of bankruptcy?
That is a critical, clarifying question.
You're asking if the writ of attachment is used within the bankruptcy process.
What's fascinating here is that the bankruptcy system has its own protections.
Okay, let's unpack this. The writ of attachment is a pre-judgment remedy.
It's used by a creditor outside of bankruptcy.
It secures assets before a lawsuit is concluded.
Once the bankruptcy is filed, the automatic stay kicks in.
That stay immediately stops all collection efforts, including any RIPs.
So the writ of attachment is generally not filed after bankruptcy
Hey, yeah, what's up?
So can debitors transfer properties once bankruptcy is filed?
That is a crucial question about the debtor's actions.
You're asking if debtors can transfer property after filing.
And the short answer is no, they really shouldn't.
If we connect this to the bigger picture, the estate is already formed.
The moment the petition is filed, all assets become part of the estate.
If the debtor transfers property after filing, it is a huge problem.
Okay, let's unpack this. The trustee's job begins immediately.
Their powers are designed to prevent exactly that kind of transfer.
They don't need the writ of attachment.
Instead, the bankruptcy trustee has their own special powers to undo this.
These powers are designed to prevent the debtor from hiding or transferring property.
They have powers of avoidance.
This is their right to void certain sales or transfers.
The trustee's power is what prevents the debtor from hiding assets for the estate.
The trustee can also use their power to take back property transferred within 90 days.
That's called a preference, making sure one creditor isn't favored.
So if property is transferred after filing, the trustee will definitely reclaim it.
The goal is to ensure that the distribution to all creditors is fair.
They ensure that the debtor gets the basic necessities for a fresh start.
And that wraps up our deep dive into the world of credit.
Oh, yeah,
So then, like, there's like certain property that is exempt from Chapter 7 bankruptcy, like, for example, the tools of the trade, like
Oh, go for it.
vehicles, home equity. But what other,
Oh, yeah. Go on.
what other property is exempt from Chapter 7 bankruptcy?
That is a perfect question to follow up on the exemptions.
You're asking for the full list of what is protected.
You're absolutely right that the law wants you to keep essential items.
We already covered the homestead exemption for shelter.
And you just mentioned vehicles, which are protected up to a certain value.
Okay, let's unpack this. There are a few other major categories.
Another one is reasonably necessary clothing, household goods, and furnishings.
That includes household appliances, too, all up to a set amount.
We also have jewelry that is protected, again up to a specific value.
And, crucially, as we discussed earlier, the tools of your trade are exempt.
That ensures you can still earn a living after debt collection.
Also protected is a portion of unpaid but earned wages.
And very importantly, oh yeah,
So then, the
Yep, go on.
so then, like, a creditor's meeting happens if
Oh, go for it.
if a company like a LLC or a type of corporation like a C corp files a Chapter 11.
Oh, back to our listener. What's up?
Is when they file Chapter 11, which is like a reorganization.
Yeah,
Is when when the company
Oh yeah, let's hear it.
is when the company would rather attempt to reorganize.
Oh, yeah,
Would attempt to reorganize rather than liquidating
Oh, yeah, let's hear it.
the company, and then the creditors meeting. So then, like, instead of filing Chapter 7, the LLC or the C corp decides to file a Chapter 11. So then, to file a Chapter 11, they would have to have a creditors meeting, but then they retain control of the what is it, the dips or whatever, and then they would have to have a meeting with the creditors.
Hey, yeah, what's up?
The creditors would have to accept that reorganization meeting, as in like they would have to accept the plan that the company decides to do to attempt to repay the debts. But the thing is,
Oh, yeah, uh-huh.
if the company is worth less than $2.7 million, then there doesn't need to be a creditor meeting.
You are absolutely connecting the dots on Chapter 11.
That's right. You've perfectly described the reorganization process.
And you brought up a really important exception for smaller businesses.
Okay, let's unpack this with the $2.7 million number you mentioned.
You're referring to the small business debtor designation.
Here's where it gets really interesting. If the debt is under that limit,
Specifically, liabilities not exceeding $2.7 million.
and crucially, the debtor does not own or manage real estate,
Then they can use a fast-track procedure.
this procedure allows them to avoid having an unsecured creditor committee.
That unsecured creditor committee is often a major hurdle in Chapter 11.
Oh, go for it.
So then, like, if the property,
Oh, yeah. Go on.
if Chapter 7 is, it goes through and all the assets
Oh, yeah. Uh-huh.
and all the assets in the estate have been liquidated, um, the
Yep, go on.
the trustee would start to distribute the funds, the money, to the creditors
Oh, go for it.
in the order of operations. Like the top first,
Oh, back to our listener. What's up?
the very first creditor that would get paid would be the secured creditors. Like
Ah, yeah,
the secured creditors that had collateral, and then it would be like
Oh, yeah. Let's hear it.
it would be like child support or like
Oh, yeah, uh-huh.
or like alimony payments. Which, those are unsecured.
Oh, yeah, let's hear it.
Those are unsecured creditors, but they would still be paid next, and then it would be but then and then
Hey, yeah, what's up?
what is the order of operations in regards to the creditors?
That is a critical question about the distribution hierarchy.
You are asking for the priority of payment in Chapter 7.
You are absolutely right that secured creditors are paid first.
Okay, let's unpack this. The trustee distributes funds in a very specific order.
The first priority goes to the secured claims.
This includes creditors who have collateral, like the bank on a car loan.
They get their collateral or the proceeds from its sale.
Next come the unsecured priority claims.
This is an important category you mentioned.
This includes things like domestic support obligations.
So alimony and child support payments are high priority.
Also included are certain tax obligations.
And certain unpaid employee benefits.
These claims, even though unsecured, are paid before general creditors.
Finally, we get to the unsecured non-priority claims.
These are the general unsecured debts.
Think credit card companies and medical bills.
They receive a proportional distribution based on what remains.
You are right that the goal is equitable treatment within those classes.
So that order secured, then priority unsecured, then general unsecured is key.
It dictates who gets paid and when in Chapter 7 liquidation.
Oh, yeah, uh-huh.
And then like there's certain debts that aren't discharged by bankruptcy, like for example, taxes.
Oh, go for it.
Like back taxes are not discharged by bankruptcy. Child support payments, alimony payments,
Oh, yeah. Go on.
student loans. What else? What other debts are not discharged?
Oh, yeah.
What other debts are not discharged by bankruptcy?
Ah, that is a very important clarification.
You are right to question which debts are not discharged.
You mentioned back taxes and student loans.
Okay, let's unpack this. You're asking why they are exceptions.
That's right. The law has decided that some debts are too important to simply vanish.
So, while the goal is a fresh start,
The discharges are released only from dischargeable debts.
things like most credit card bills are wiped out.
But back taxes and student loans are notable exceptions.
If we connect this to the bigger picture, it's about fairness to the system.
You're right to focus on that.
You're pulling us right into the exceptions to discharge.
And you've named another major critical exception, student loans.
They are generally not discharged unless there is an undue hardship.
That is a very high bar to meet in court.
Discharge is the release from your dischargeable debts.
This order is why Chapter 11 and 13 plans have to be accepted.
The creditor... yep, go on.
And what are the 5 objections to bankruptcy discharge?
That is a fantastic and very precise question.
You're asking about when the court can deny that fresh start entirely?
Okay, let's unpack this. There are 5 main objections that can lead to the denial of discharge.
The first and most serious is fraudulent concealment of assets.
If the debtor hides property from the trustee, the discharge is denied.
The court can also deny discharge if the debtor made a false oath or account.
That means lying under oath during the proceedings or on the petition paperwork.
The third is if the debtor failed to explain the loss of assets adequately.
If a lot of money or property vanished right before filing, that raises a flag.
The fourth objection is prior discharge within 8 years.
If the debtor received a discharge in another case too recently, they are ineligible.
And finally, the fifth is failure to complete consumer education.
Remember we talked about needing that credit counseling beforehand?
You also need to take a financial management course afterward.
If you fail to attend that course, the discharge can be denied.
So those 5 can... Oh, go for it.
And what is the reaffirmation of debt?
That is a critical question about what happens after the bankruptcy is filed.
You are asking about the reaffirmation of debt.
Okay, let's unpack this. Reaffirmation is taking back a debt.
It's a formal agreement you enter into during bankruptcy.
You essentially agree to pay a debt that you could have discharged.
If we connect this to the bigger picture, this mostly relates to secured property.
For instance, if you want to keep your car or your house,
Even though the debt on it is dischargeable in bankruptcy,
you must enter into a reaffirmation agreement.
this legally ensures that you will continue making those secured payments.
Otherwise, if you walk away from the debt, you must give the...
Oh, back to our listener. What's up?
So then, like, Chapter 11 bankruptcy is for corporations such as an S corp or a C corp or a limited liability company that would like to
Yeah,
that would like to attempt to reorganize rather than filing a Chapter 7 and
Oh, yeah, let's hear it.
filing Chapter 7 and liquidating all their assets, liquidating the company.
Oh,
Um,
yeah,
Because, like, if the company files a Chapter 7, the estate of trustees would immediately
Oh, yeah, let's hear it.
liquidate the entire company, essentially closing the company. So then, if they file Chapter 11,
Hey, yeah, what's up?
so if they file Chapter 11, they can keep the company going and using some type of
Oh, yeah,
using some type of plan that needs to, if the company is worth over $2.7 million, the plan would have to be
Oh, go for it.
accepted by the council of creditors.
Oh, yeah, go on.
The creditors meeting, they would have to agree to the plan that the board of creditors would have to
Oh, yeah.
would have to accept that plan. And then if
Yep, go on.
the board of creditors in the creditors meeting accepts that plan, then the company
Oh, go for it.
and the company can retain control of the company and not have to liquidate their assets.
Oh, back to our listener. What's up?
And then they can attempt to repay the debts to the creditors. Is that correct?
That's a great summation of Chapter 11 and how it avoids liquidation.
You are absolutely right. The plan's acceptance is the key difference from Chapter 7.
And circling back to that reaffirmation agreement we were just discussing,
The alternative for secured debt is giving the property back.
if you don't reaffirm, you must give the property back.
You're right. Otherwise, they can't attempt. Yeah.
And then Chapter 12 is
Oh, yeah. Let's hear it.
Chapter 12 is specifically for farmers or fishermen that
Oh, yeah,
that decide to not follow Chapter 7 and instead follow Chapter 12.
Oh, yeah, let's hear it.
Instead follow Chapter 12. And they'll set up a payment
Hey,
plan.
yeah, what's up?
Set up a payment plan for fishermen and farmers. But the thing is, they can't.
Oh, yeah,
Farmers can't be involuntarily forced into filing for bankruptcy.
That is a critical point about involuntary bankruptcy.
You are absolutely correct to flag that exception.
Okay, let's unpack this with Chapter 7.
You're right. Farmers and charitable institutions cannot be forced into involuntary bankruptcy.
That loops back to why Chapter 12 exists.
It gives them that specialized repayment plan protection.
It allows them to avoid that forced liquidation.
Otherwise,
Oh, go for it.
So then chapter 12 would,
oh yeah, go on.
so for chapter 12, the farmers wouldn't liquidate their assets. Instead, they would be on a repayment plan with the creditors.
Yes, you are perfectly summarizing Chapter 12.
That's exactly right.
If we connect this to the bigger picture, oh yeah,
But would the farmers have to have some type of plan that has to be accepted by some type of board of creditors in a creditor meeting?
that is a brilliant question.
You've hit on the crucial element of any repayment chapter.
You're absolutely right that a plan must be accepted.
Okay, let's unpack this for Chapter 12.
While it is similar to Chapter 13, it involves a plan.
The family farmer or fisherman proposes an adjustment plan.
Unlike Chapter 11, where creditor committees vote on acceptance.
The court ultimately confirms the Chapter 12 plan.
The trustee will ensure that the plan is viable and fair.
It has to make sure creditors receive at least as much.
That is, as much as they would get in a Chapter 7 liquidation.
So acceptance is confirmed by the court, not... Yep, go on.
And then, like, for chapter 13, essentially what chapter 13 is if, for example,
Oh, go for it.
is if a individual,
Oh, back to our listener. What's up?
if an individual or a sole proprietor who has personal liability and personal assets attempt to file a chapter 7,
Yeah,
attempt to file a chapter 7, but then they fail the means test.
Oh yeah, let's hear it.
But they fail the means test, and it ends up showing that they actually do have disposable income that can be used to pay for the debts. Then they'll be put on a repayment plan.
Oh, yeah,
They'll be put on a repayment plan for chapter 13 rather than chapter 7. But would a
Oh, yeah, let's hear it.
would a individual rather file a chapter 7, but they're
Hey, yeah, what's up?
so they're unable to file chapter 7 if they want, even if they wanted to?
That's a great question about the individual's choice
You're asking about the means test again.
and whether an individual must file Chapter 13,
If an individual fails the means test,
meaning they have disposable income.
they are indeed barred from Chapter 7.
So they are unable to file Chapter 7.
The court often pushes them to Chapter 13.
That repayment plan is the path forward then.
This is to prevent the abuse of Chapter 7.
So acceptance is confirmed by the court, not necessarily a creditor vote,
It ensures that the plan is viable.
and that creditors are treated fairly. Oh, yeah,
Okay, well, I think that's enough, and I'd like to end the podcast. Thank you.
That's very kind of you to say that.
Oh, thank you. It sounds like we covered a lot of ground today.
We truly did, from the artisan's listen to Chapter 13 plans.
It's been an intense look at the whole system, but so much fun.
Absolute balancing the debtor and creditor needs has been a great discussion.
We really appreciate all your insights and fantastic questions,
Your clarifying questions really helped us connect the dots on those liens.
especially the difference between the writs and the surety rights.
It highlights how complex debt resolution truly is in the legal system.
Thank you so much for joining us today and for all your participation.
We always love it when you jump in and guide the conversation.
We hope this deep dive into bankruptcy and debt collection was useful.
Be sure to join us next time for another fascinating topic.
Have a great rest of your day.